is in default. I did receive your proposed order. We thank you for that. I do want to talk with you a little bit about the nature of the order that I might enter on your default, given some of the causes of action that you have. So if you'll sit tight for a minute while I just finish running through my calendar, then I will circle back to you in just a moment. Okay, sir?
On standby, Your Honor. Thank you.
Thank you. Capital One versus Pamela Crutcher. Do I have anyone here on behalf of Capital One? Mr. Freehoff, can you check and see if anybody from on behalf of Capital One even opened the notice? Thank you. And then I have Amir Navabi versus Patrick Smith. Do I have anyone here on behalf of Amir Navabi? Do I have anyone here on behalf of Patrick Smith? Mr. Freehoff, can you also check and see if they open their notices? Thank you. And then I have Elon Hall, HOA versus Deborah Mitchell. Mr. Cooper?
Good morning, Your Honor.
Good morning, sir. And do I have anyone here? Again, I know it's a default, but is anyone here for Deborah Mitchell? Okay. Mr. Cooper, I'll make part of your job really easy, which is that I have reviewed the record. It's clear to me that y'all filed. The actual proof of service was filed a little bit late after actual service was secured on August the 28th. It wasn't filed until September the 15th. My review is that technically Ms. Mitchell still has until today to file a motion to open default as a matter of right. I think that's unlikely, but if it happens, we will obviously let you know. You'll be aware when it gets filed. If it, as I expect, does not happen, then my intention is to enter the order based on the motion that you submitted tomorrow at a time when it will be clear that no effort to open the default has been filed.
Certainly.
And so if you could just go through your attorney's fees to make sure that I have that information. I know you filed an affidavit. Um,
Yes, Your Honor. And to on the proposed order that we sent over, it does reference the date that the defendant was served. I'd be happy to send over an amended, revised proposed order.
don't worry, I've
Okay.
already I rewrote it with the language and the dates I wanted in it.
Okay.
So it's fine because generally I like my default orders to say they were served on X date and then they had until this date to answer. They defaulted and then that sort of thing. And so it's fine. I still very much appreciate that you sent over a proposed order because it gives me something to work with. It's easier to edit than it is to write from whole cloth. So,
Well, thank you, Your
but
Honor. So I will I'll testify to the fees in this case. So I'm an attorney authorized to practice law in the state of Georgia and have been since 2013, associated with the firm of Nowak Howard. My hourly rate as a senior associate is $350 an hour. Nowak Howard has performed legal services on behalf of Elon Hall in the collection of unpaid assessments, related fees, and charges from the defendant in this matter. On behalf of the association, Nowak Howard sent the defendant notice of the debt and the association's intent to collect. Its intention to filed suit, perfected service, and prepared and filed a motion for summary judgment, which is before the court today. The legal services described, not including attorney's fees for today's hearing, has resulted in the expense of the association of $3,207.80. And I have the itemized fee statement is attached to my affidavit as Exhibit A. The affidavit that accompanies the motion for default judgment. These amounts are detailed in this statement. This statement is a business record for the firm, and it's the regular course of business for the firm to make and keep such records. The entries appearing on the statement are made at or near the time that they occurred, made by or from information transmitted by someone with personal knowledge and a business duty to report, and subsequently reviewed for accuracy. The hourly rates were performed, time spent, total expense incurred for the legal services rendered in connection with the case are reasonable and customary in light of the nature and complexity of the work. And we would request an additional 0.5 hours, so $175 for preparation and attendance of today's hearing as well.
Okay. And that all seems appropriate. As I said, based on the matters that you had submitted previously, it does appear to me that you that the hours are reasonable and necessary and that they are due to be awarded. I do want to make sure that I have your numbers current and correct. I have $3,212.37 in principal, $158.52 in interest. And then I think that whether because of the time that has passed or the addition of the 0.5, that maybe the number I have for attorney's fees in your proposed order is different. Can you tell me what that total number is that you're seeking? Is it the $3,207.80 you just mentioned?
The total for the attorney's fees. Sorry, Your Honor, let me make sure I'm telling you the right number. For the attorney's fees, with the additional 175 would be $3,040.
Even?
Yes, Your Honor. And
Okay.
the total then would be the total order judgment would be the $7,003.71.
Okay. And then just to finish, in addition to now the $3,040 in attorney's fees and then $342.80 in collection costs, $250.02 in court costs for a total of $7,003.71. Is that correct?
That's correct, Your Honor.
Okay, excellent. So I have that order proposed and ready to go. I will we will check the docket, which by we, I mean Mr. Freehoff. We'll check the docket tomorrow morning and see if anything has been filed seeking to set it aside, or to, excuse me, open default as a matter of right. Assuming that it has not, then we will go ahead and enter that proposed order tomorrow at a time when it is ripe. Okay?
Thank you, Your Honor. And I believe that concludes my business. May I be excused?
It does. Thank you. Have a good day.
You too. Thank you.
Okay, so those are all of the matters I have for today. Is anyone here on any other matter before I circle back to Mr. Tumlin? Okay. So Mr. Tumlin, the reason I wanted to follow up with you is, as I said at the beginning, Mr. Goldberg is entitled to a default judgment, based on the dates, etc. What I did want to make sure, though, is my review. So one thing is, there is the complaint that you filed, right? So now that you have the default judgment, I need some evidence regarding the amount of the damages because, as I understand them, they are unliquidated. And the only concern I wanted to share with you is I understand when lawyers file complaints, right? We file anything that is a theory that might stick. But even on a default, I believe it's my obligation to sort of check and confirm that, as a legal matter, the causes of action would survive. And while I think that you probably have a breach of contract, I mean, you have stated a breach of contract claim, based on prior experience or oral agreement, et cetera, and that you have stated a claim for unjust enrichment. I'm not sure that this falls into what I would understand to be an open account. You might have been able to prove it through the course of the case, but I'm just not sure that I'm not sure it necessarily helps your client to have a potentially weak claim sitting out there as a default when you have legitimate claims for which you are entitled to a default judgment and for which you can provide clear evidence. And so, as a function of all of that, I leave it open to you to convince me otherwise. But I think my initial indication would be to grant you a default judgment as to the breach of contract, the fraud, and the unjust enrichment. Well, in the alternative, right? Because, if there's a contract, then there's not unjust enrichment. So we need to pick a horse and ride it, right? And then tell me what your damages are in terms of offering up evidence as to the damages that you want the court to enter in the judgment. Does that make sense, Mr. Tumlin?
Yes, it sure does, Judge. And I was sort of anticipating that. So I'll start by stating the breach of contract and the open account are very similarly related. This is a case that is based on prior business dealings between the parties. in which my client acts at the request and direction of the defendant. And that is what happened in this case. There was no new written contract to govern the parties. Therefore, it is an oral contract, but oral contracts are valid in Georgia so long as they are proven up. And I think our well-pled complaint establishes that an oral contract was made between the parties for him to perform services. So the open account aspect of it essentially state that he, as a non-employee, essentially third-party vendor of Roof 911 LLC, has, a line of business with the defendant to establish accounts. And that's what he did in this case is he developed a piece of business in South Carolina, and I have the homeowner of that estate on Zoom with you as well to help clarify some damages for you. His name is Kelly Combs. But Your Honor, we would be fine with taking a default judgment on count one, breach of contract. The open account was pled in the alternatives in case you had an issue with the oral contract being established. But what I'm hearing from the court is you believe that it's valid and would survive. So we'll proceed on the breach of contract if it pleases the court.
Oh,
So-
it does. Go ahead.
All right, very good. And as far as it relates to the unjust enrichment, that's the equitable claim that saves us in the event that while litigating, everything else fell through. I do think, and I want to point out that the Superior Court has equitable jurisdiction and that venue and jurisdiction would be proper in this court based on anything and everything that happened in the case, as Mr. Goldberg will explain for you in a moment of how this developed for an unjust enrichment case. But I think that the breach of contract would suffice. As you noted in my proposed order, we do have some liquidated damages because we have a math problem we can do on what the amount to be paid under the contract was, right? But we have to have this hearing with you because we also have some unliquidated damages in the form of general tort damages for my client's essentially his pain and suffering and mental anguish that the defendant's actions have put him through, including my attorney's fees, which require a hearing for me to establish the reasonableness thereof. And I'll get into that as well. But Judge, if it pleases the court, I would call my client first.
Okay. Mr. Goldberg, can you unmute, please?
Yes,
And can you raise your right hand? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. And Mr. Goldberg, I realize you need to stay muted because y'all are both in the same room, and that's totally fine. If you'll just make sure and speak up loudly so that I can hear you. I can hear you, but you're a little muffled, okay?
Okay.
Very
Thank
good.
you. Go ahead, Mr. Tumlin.
All right, Mr. Goldberg, are you one and the same as the Charles Goldberg as the plaintiff in this case?
Yes.
Okay. And you authorized me to file this complaint on your behalf?
Yes.
And you swear to the judge that all the averments therein are true and correct?
Yes.
Mr. Goldberg, can you describe to the court your what caused you to go down to the Augusta area in the aftermath of Hurricane Helene?
I was given a call by Mr. Dev Zedek, who I worked with in the past, that this area was a good area that we should try to work a claim. So I immediately listened to him and started working and secured the property from Mr. Combs.
Mr. Goldberg, are you an employee of Roof 911 LLC?
No,
Okay. And are you effectively retired as
I
it
am.
stands now?
I am.
Were you at the time Mr. Zavednik contacted you to develop business for storm damage remediation in the aftermath of Hurricane Helene?
Yes,
Okay. Did you in fact travel down to that area in hopes of developing business for the defendant?
absolutely.
And what was your expectation of your compensation package for this work?
I was told I would get 40% of any monies collected by the corporation or personally by either Dev.
And is that consistent with your prior business dealings with this particular defendant in developing business?
It is.
In what states have you worked on behalf of this defendant in the past?
Texas, Georgia.
When you went down to the Augusta area, did you eventually cross the border into South Carolina?
I did.
And did you develop a stately property for storm damage remediation?
I did.
What was the name of that property?
Rosemary Hall.
Describe to the court Rosemary Hall.
It's one of the oldest properties, maybe the oldest property in Augusta, Georgia. It's a beautiful building or home that Mr. Combs has, and it's something that is, I believe, a historical monument.
And when you say Mr. Combs, are you referring to Kelly Combs?
I am.
And did you have any prior knowledge or relationship with Kelly Combs?
No, I did not.
All right. Are there other people in this line of business competing to sign up accounts for storm damage remediation?
Oh, absolutely, yes.
When you met with Mr. Combs, had he ever heard of 911, Roof 911 USA LLC?
Never.
All right. And what did you do to promote that company to Mr. Combs?
I told Mr. Combs, Mr. Combs told me that he needed more than a roofer because the property was a historical of nature. And I said, well, I have the perfect person who can direct the proper replacement of the roof. And his name is Dev Zenik, and it's Roof 911.
Based on your dealings with Mr. Combs, did you eventually develop that project and deliver it to Roof 911 USA LLC?
Yes, I did.
All right. Did you have, based on your prior experience, did you have an idea of what that job may generate in terms of gross proceeds to the defendant?
Not really, not until it was inspected, but I never got any kind of paperwork from Mr. Zenik as to the amount of the claim.
Okay. Did you try to get paperwork or follow-up information from the defendant
Oh,
about the work being done?
Absolutely,
Did you eventually investigate and discover that work had in fact been done on the home?
I did.
And did you learn that it was done at the behest of Roof 911 USA LLC?
Yes, I did.
Did you ever make demand from Roof 911 for payment on this contract?
Yes, I did.
And what were you told?
I was told that I was not going to get any commission.
How did that make you feel?
It made me feel destroyed because I was counting on that income.
When you say counting on that income, what types of things were you earmarking the commission earned to do?
Pay my bills.
Okay. Did you ever have to borrow money to make ends meet by not receiving any commission on the project?
I sure did, yeah.
Okay. Who lives in the house with you?
My granddaughter is 17. She lives with us. My wife, my granddaughter, 5 years ago on my son's birthday, I got a call that my daughter-in-law fell, hit her head and died. And I had to tell my granddaughter that her mother wasn't waking up. But we decided, we were in Pittsburgh at the time. We decided to move back to Georgia, and she lives with us now, and we've been taking care of her.
Is your wife retired?
Yes, she is.
Do you guys have any substantial source of income?
No, we just have Social Security.
Are you responsible for the care of your daughter
I am,
or your granddaughter? I'm so sorry.
my granddaughter, yes.
And had you relied upon this money to, I guess, compensate yourself and recoup a lot of the expenses that you've expended upon her since taking over her care?
Absolutely.
Okay. Have you thought about this often ever since you were told from the defendant that you were not going to be paid?
I think about it every day, yes.
Mr. Goldberg, did you ever have occasion to try to negotiate further with him about payment?
Yes,
And when I say him, are we referring to Dev Zvednik?
yes.
All right. And were you ultimately made some type of offer to settle the compensation disputed?
I was actually made two offers. One offer was 10% of the claim, and then he rescinded that and sent me a new contract that just paid me $100 for every phone call that I made. So that I would get $100 from Mr. Zedek on the claim.
And he sent you that to try to get you to put in writing that you would settle your compensation due for $100 for every phone call you made.
Yes,
Did you reject it?
yes.
What did you advise him you were going to do at that point?
I told him I was going to try to litigate this if I could.
When you say try to litigate this, describe to the court your problems in getting an attorney retained to take this case on.
Well, first of all, I do not have the income to pay $350 to $500 an hour for an attorney to handle the case. And it's just that simple.
And when you contacted me, were you able to post a $3,000 retainer just to begin work into the case?
I was, but yeah, it was a strain to come up with the monies to get the necessary paperwork served and everything, but
After discussing the litigation strategy and how these cases often go, were you going to be able to continuing to post replenishing retainers to justify any work moving forward?
no,
And were you under the impression that if retainers weren't posted, then the attorney would have the right to withdraw on the case?
yes,
All right. Did you eventually discuss a contingency fee agreement on the case?
I did.
And what was your understanding of that contingency agreement?
That I would pay 40% of my proceeds to the attorney.
Okay, so 40% of the 40% that you were legally trying to recoup through litigation.
That is correct.
All right. And did you understand that to include pretrial matters, trial matters, and post-trial matters?
Yes,
Okay. And you were prepared to meet that obligation and pay that amount out of any proceeds that you received?
absolutely.
All right. To date, did Dev Zavednik on behalf of, or anyone on behalf of Roof 911 USA LLC, did anyone ever give you any proof of proceeds generated in regard to the Rosemary Hall project?
No.
And how did you eventually get that document?
Mr. Combs was able to supply that.
And upon review of that document, which, Judge, I'll just note for you is in my default judgment motion as, I believe, Exhibit A, but it is a statement of what I've labeled gross proceeds received from Roof 911. And Mr. Goldberg, did you learn through that documentation? Well, let me ask you this. Did you recover that document before or after you filed the lawsuit?
After,
Okay. And is it your understanding from that document that approximately $1.25 million were approved for payout on the storm damage remediation project?
that's correct.
And that is the project that you developed?
That's correct.
Okay. Based on review of that document, did you see amounts totaling $875,400 as paid out to Roof 911 USA LLC?
Yes, I did.
Have you ever been paid a single penny on those proceeds paid out to the defendant?
No, I have not.
Okay. And you are asking the court to award you 40% of those gross proceeds in line with your contract established with the defendant. Is that correct?
That is correct.
Now, Mr. Goldberg, we also have this matter of general damages, which are damages that we can't calculate with a math problem or point to receipts and whatnot. Is that correct?
Yeah.
And you are seeking these damages from Judge Krause in regard to the tort claim. Is that correct?
Yes,
All right. And those damages are to account for your essential mental anguish that you and your family have been through as a result of this whole ordeal. Is that right?
yes.
All right. Mr. Goldberg, Judge, that would be my showing from Mr. Goldberg.
Okay. For my benefit, can you tell me the number regarding for the math problem number? I have the larger number of the 875, but nobody wants me to do math, even something as simple as that number times 40%. And the actual number of your attorney's fees.
Okay. So, Judge, I will state in my place before we get down to that number. Let me state in my place that that I am a practicing attorney admitted in Georgia and Florida. I have been practicing since 2009. I'm a graduate of the University of Georgia. I've practiced, my first job out of law school was in mass tort down in Florida doing tobacco litigation on a defense firm. And after a year of that work, realized that I was proud of where I came from and came home to Northeast Georgia. I worked
Side note, I did the same thing. I got married and my husband dragged me to Florida and then I dragged him back.
Ah,
So,
very good. Well, it's interesting. I'm going to go back this weekend to St. Simon's to revisit my old stomping grounds where I lived while I was practicing law in Florida. But that's important and relevant because I've been involved with high stakes business matters in a portion of my career. But back in Northeast Georgia, I operate, as you may or may not have seen or learned, but I do a general practice in Northeast Georgia with a lot of DUI litigation and personal injury litigation. But I also represent several businesses in my community as general counsel, many of whom have been subject to collection efforts similar to this. And I've had to litigate with some of the best attorneys in the business. I'll state Brian Kaplan for you, that I've been through the other side of this with and spent many, many, many hours in post judgment litigation concerning seizure of business um, assets in order to satisfy judgments and whatnot. That's important because we have a contingency fee agreement here, and there's some cases out from the Supreme Court that require demonstration of the attorney to justify a contingency fee. I will tell the court I didn't keep up with hours on this case because I did take it on a contingency and I believed in the case and did a great deal of research on the front end into the defendants and their subsidiaries and their operations from Texas to South Carolina to Florida.
yeah.
Judge, I did a great deal of preparation for anticipated discovery that I wanted to have submitted the day that the answer was filed, which never came, and was going to take multiple depositions and engage in multiple forensic accounting measures and whatnot. So we were prepared to spend a great deal of time on this case and spent, I'll tell the court, I'll probably estimate 80 to 100 hours on it preparing for this big fight because this is a regional corporation that is engaged in high dollar business, Judge. And so, anyways, aside from all that, the court knows that once a judgment is obtained in a case like this, it's not over. We don't have an insurance company that's paying us a contingency fee. We have a business with a lot of options to try to avoid payment of the judgment. So even after today, we expect to be engaging in post-judgment discovery. We expect to be engaging in forensic accounting of all accounts and tracing the money. We expect to be piercing the corporate veil. We expect, unfortunately, we're prepared to chase the owner of the company across national lines in this case because the money damages are going to be significant. Judge, to answer your question, I think we first have to have an award on the general damages so I can apply my 40% contingency fee to it as well.
Right. And that's
Um,
actually what I was asking for clarification on. And I do appreciate that, is that the attorney's fees that you will be claiming are entirely based on a contingency fee, which is fine. And I think I heard you say 40%. Is that right?
yes, Your Honor, that's right.
Okay. And then
So,
the actual dollar amount I missed was, as I said, I understand the $875,000 and change, obviously, amount of invoices. And I think your proposed order had reduced that amount to $350,160. Is
That
that?
that would be the contingent. That would be Mr. Goldberg's
Mhm.
commission due and owing on the gross proceeds paid to the defendant. So,
Okay, and
we-
that's the part I was trying to make sure I understood. I understand that you're alleging additional other damages
correct.
before you reduce that to the amount of your attorney's fees. I just wanted to make sure I had the number for the gross receipts. And
Very
it
good,
is
Your
that
Honor.
350, 160. Okay.
Yes, Your Honor. And so we would ask you to award attorney's fees. We would ask you to award that amount to my client as special damages that can be liquidated based on the contract. And then we would ask you to enter an award of $140,000 and $140,064 in attorney's fees on that amount. That's what 40% of that 40% figure comes out to. Judge, we're
Okay.
also asking for you to award general damages on the tort claim for what you've heard from my client of the mental anguish that he's been through, having developed a very stately project that resulted in a 1.25 million piece of business for the defendant, upon which we know and I'll demonstrate this in a moment from Mr. Combs. What we know, the defendant was paid on the case. So my client has been expecting and should have been paid these commissions promptly, but wasn't, and has had to essentially go through hell. And he had decided that there were uses for that money he'd like to get into, but couldn't do it because he wasn't getting paid. Anyways, Judge, we would ask you to just consider awarding $140,000 in general damages on that tort claim. We find that that is less than half of what the special damages are on the contract claim. We find that that is a number that is equal to the attorney's fees due and owing on the contract claim, and we feel like that is a number that is representative of the mental anguish that my client went through, that is reasonable under the circumstances. But we also defer to the court's discretion because you are operating as the conscious enlightenment of you're the consciously enlightened jury in this case, since we're in default. So you've probably handled dozens of these, if not more, and could probably fashion a good number for us on the general damages. And then I would ask for you to add 40% of whatever that amount is in additional attorney's fees due and owing to my client for attorney's fees that he will eventually pay out to me from his proceeds.
Okay. Thank you,
Yep.
Mr. Tumlin. And then if you want to go ahead and call your next witness.
I do. Mr. Combs, are you online, and could you bring your camera? Sir,
Yes, I am.
would you
Hi,
raise
Mr.
your right?
Combs. Sorry. I usually just swear the witnesses and myself. Mr. Combs, thank you very much. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Go ahead, Mr. Tumlin.
All right, sir, would you describe to Judge Krause who you are and the stately home you own down there in North Augusta, South Carolina?
Yes, I'm Kelly Combs. My wife and I moved here 16 years ago. And by the way, it's North Augusta, South Carolina, but it is the Augusta area. And we purchased the founder of North Augusta's historic home. It is on the National Register of Historic Homes. And this was, again, the founder's home. There was another one across the street, his brother's home. We purchased both of them and fixed them up from their more deteriorated condition and ran them as bed and breakfast inns up until about 2-3 years ago.
On your property described as Rosemary Hall, which is outlined in my complaint, did you suffer storm damage as a result of Hurricane Helene with regard to that property?
Yes.
All right. Prior to suffering that storm damage, had you ever met Charles Goldberg?
No.
When you first met Charles Goldberg, describe to the court his promotion of Roof 911 USA.
I was convinced. He did an excellent job. I would consider that initial phone call, later visit by Chuck to be what convinced me to go with Roof 911 USA.
Did you have any prior knowledge of or relationships with Roof 911 LLC or any of its subsidiary businesses or personnel working for it?
No.
Had you ever even heard of it?
No.
All right. And did you eventually sign a contract with Roof 911 to do your storm remediation business?
Yes.
And but for the efforts of Chuck Goldberg promoting that company, would you have ever even had the occasion to sign that contract?
No.
Did you guys utilize the assistance of a public adjuster on this claim?
Yes.
And did you learn the amount of monies approved for disbursement with regard to this claim?
Yes.
And what was that amount?
The total claim was around $1.3 million.
Okay. And were you provided with a statement of proceeds that have been paid out on behalf of your project?
Yes.
Okay. And in that statement that I've attached in our complaint, did you provide that to my client and to me?
Yes, let me just clarify, there's a statement of what was paid on the entire claim. And the roof portion was a little bit less than that. However, what was paid so far to date to Roof 911 is the statement which I provided.
And that would be $875,400 paid to them.
That's correct.
Sir, have you received a single dime of those monies that were paid out to Roof 911 USA LLC?
No,
Okay. And you don't expect to recoup any of those monies that were paid out to them for performance of your storm damage remediation, do you?
no.
Okay. Your Honor, you may have some questions for Mr. Combs.
I don't.
Okay. That would be all from you, Mr. Combs. Thank you so much.
Okay, thank you.
Thank you, Mr. Combs.
Judge, my paralegal's on the line and she's just observing. She's brand new and getting started in the business, and her name is Hallie, so I'll introduce you to her.
Hi, Hallie. Welcome.
Hello, thank you.
Judge, that's my showing. And if I could just state to the court that what we have here is an awful situation. In retrospect, I probably should have filed for punitive damages. But I didn't, because I expected that we would get the benefit of litigating this claim and going through discovery and, settling it through a more normal procedure, but we didn't get to do that. What you've heard this morning is Roof 911 USA LLC knew that there were going to be rich opportunities in the Augusta, Georgia area for storm damage remediation. And the president of this company called my client and put him into action in the field on their behalf to develop projects. And my client developed a big one, a very stately home, Mr. Combs' home down in North Augusta, Rosemary Hall. That was a $1.3 million job, as you just heard. And we know that they received amounts paid in a document that we've attached to our motion for default. This company has received $875,000 in proceeds paid out on that claim, and offered my client $100 for each phone call that he made. Judge, it's not hard to understand the mental anguish that someone would develop when they go to work while retired with a lot of obligations and land such a big job and have a dream of recouping based on prior dealings with these folks who have paid out in the past without issue. This is shocking to my client. And he's, as he told you, devastated as a result of it. Judge, he's had to go contact a lawyer. He was unable to pay for any litigation in advance at an hourly rate that could be mapped and tracked. And the only thing that he could do on the case was to enter a contingency agreement should he find a lawyer who was willing to engage in such an agreement, because the court knows that just because you get a judgment doesn't mean you're going to ever collect it. There's so much work to be done on getting the judgment, recording it, and then collecting it. And we have no earthly idea how this is ultimately going to go. But I took the case on a contingency fee agreement after investigating these companies and my client's claims, and knew that that was the only way for him to obtain justice, was to engage us on this leap of faith that we could get a judgment in a stated amount and then actually go and collect on it. And so that's the challenge that lies on the back end of this for us. So we're going to ask that you find the defendant owes my client 40% of the gross proceeds collected in the amount that we have stated earlier. We're going to ask that you enter an award for the emotional distress that my client went through as a result of this, and ask you to add 40% of that number in additional attorney's fees due and owing by the defendant to my client, under our legal theories that you're granting judgment upon. Judge, that's my showing.
Okay. Thank you, Mr. Tumlin. So I do have a couple of questions about, as I mentioned at sort of the beginning, about picking a horse to ride, right? Because the concern I have about entering a judgment for you, understanding that you're going to go out of your way to try and enforce the judgment to actually recover for both for Mr. Goldberg's benefit as well as yours, given that it is a contingency agreement. But generally speaking, an unjust enrichment claim is a theory in the alternative when there isn't a contract. The fraud claim, more broadly, I think those claims could exist at the same time. But what I'm worried about doing is entering a judgment that says breach of contract, but also says unjust enrichment. Or the fraud claim, the concern I have about entering damages associated with a judgment on that, because here's the thing, you're entitled to all of them. But in terms of enforcing one of them, the concern I have is that typically those are in the alternative, and by the time you reduce it to a judgment, right, it's one or the other, not both. The other concern I have is that, and that's why I wanted to ask you about the fraud claim or the unjust enrichment claim, because perhaps it is that I mean, the breach of contract claim is fairly straightforward, right? We had a contract where I would get a commission that was, 40% of whatever was recovered, et cetera. That makes sense. It's pretty straightforward. And once the, allegations of the complaint are deemed admitted, it's there. The entitlement to attorney's fees is similarly fairly straightforward. The concern I have is that the tort damages that you're seeking to recover, while I don't dispute Mr. Goldberg's, very negative experience and the, mental hassle and pain and suffering that might have associated with it. Those are not typically damages that the court that are authorized to be granted on a breach of contract claim. They typically are associated with tort damages. And so I think I need a little more from you to make sure that when I finalize a judgment here, that it is a judgment that you will be able to defend because it's legally proper.
So I do believe we'll be able to legally defend the breach of contract and the liquidated damages on it, since it's a simple
Yes.
math problem. And the
Yep.
law is clear that I'm entitled to attorney's fees when there is a default. I just have to show the reasonableness of them, and I think I've done that today. As far as the tort, I think we could have judgment on count 1 and count 3, the contract and the tort. And I believe you could award general damages on the tort claim, and I think you could award special damages on the tort claim. Those are damages that we can map out with the math problem.
Yeah,
And
I agree, and that was really what I needed you to clarify, was that that's what you're seeking recovery on, is that the contract claim and then the fraud claim. And I think and that makes sense. Okay, thank you.
Okay, yes, Your Honor. And, with that, we are fine for the court to craft language stating that counts 1 and 3 are the legal theories upon which we've met our burdens and obligations, and judgment would be awarded on those. Counts 2 and 4, the open account and unjust enrichment. I don't think I need judgment on those. The unjust enrichment was in case everything went to went sour, I'll say. And
Sure.
but I think that we've met our burden and have a complaint that would survive.
Okay. And then one last question. The complaint asks for damages pursuant to 13611.
Yes.
And what I want to make sure that we are doing properly is accounting for, because I think that Mr. Goldberg is entitled to recover his attorney's fees. What I want to ensure is that I avoid any concern about double recovery, right? Because of the nature of how we're calculating it. So I want to make sure I understand your request so that when I reduce it to judgment, count 1, the award would be the $350,160.
Yes.
Count 3, I believe you have asked for an additional $140,000. Is that correct?
That is correct, Judge, for general damages related to the tort claim.
Right. And then as to the attorney's fees, am I correct that you're asking for $140,064 pursuant to 13611?
Yes, Your Honor.
Okay.
So that is the bad faith statute for pre-litigation conduct
Right.
of the defendant. And I think I've laid out my bases and efforts for that.
Okay.
So we're not seeking this under Title IX, which is post-judgment defense of presentation of a bad defense. We don't have that. They
Right.
didn't even bother defending the case.
I know, which is a little surprising to me. But it's always surprising to me when people don't, when they decide to hide from instead of address a lawsuit. Okay, so I think I have the information that I need. I will, I have the proposed order that you submitted. I'll just let you know in advance that my typical default orders, even where I have a full hearing on damages, as we've done this morning, typically more pared down than what you've provided me. And so be prepared when you see what you get. It'll be a lot shorter, in the sense that, a lot of times in these types of cases, I feel like less is more. And that really what I'm going to say is that there's no disputes based on the dates and the record that there is a default here, and that we had a hearing that was properly noticed, and that the defendant had an opportunity to appear, and even in default, request to be heard or to challenge the damages sought. That did not occur, and that the plaintiff presented evidence regarding the nature of their damages, both liquidated and unliquidated, as to both contract and tort damages, and evidence of their entitlement to 13,611 attorney's fees. And then, as a result of the well-pleaded allegations of the complaint being admitted, plus the evidence presented at the damages hearing, the court hereby enters final judgment in the following amounts. That's probably what it will look like. If any questions, concerns you have regarding that approach, Mr. Tumlin?
No, Your Honor, I was very thorough in giving you way more than
No,
you needed, so that
more
your
is
staff
more when
attorney.
you're giving a proposed order.
Right.
Less is more when I'm finalizing that order. So,
I do just want to make certain that when the attorney's fees are awarded under 13,611, it's important to note and make a finding that the attorney's fees are reasonable. They are substantial, but they are reasonable based upon just the conduct alleged, the anticipated amount of work going into the case, and the preparation for the litigation. Even though we didn't get to conduct it, we still prepared for it. And not to mention, we don't get to collect attorney's fees again if we have to go through post-judgment collection efforts. And so I think that would be important in the event that anyone ever tries to appeal this on the back end. I think the only thing they could appeal would be the reasonableness of the attorney's fees under 13,611. And so if there could be language in the order showing that they're reasonable for the reasons that I've given, especially considering the expected amount of post-judgment litigation to collect the judgment, I think that would be able to survive.
I understand. And I appreciate you reminding me about that language. I agree with you that it would be important to include it. And so I'll make sure and try to address that. Anything else that you need to present today, Mr. Tumlin?
No, Your Honor, it's been a pleasure appearing in your court, and
It's
I hope
nice
to
to
cross paths
meet
with
you
you in
and see
person at
you.
some point.
Yes, sir. I agree.
All right, thank you.
Take
Maybe we
care,
get to-
Mr. Goldberg, and I will see you when we have to get into post-judgment discovery, if that's what occurs.
Okay, very good, Your Honor. Thanks so
Thank you all.
much.
Have a good day.
Bye-bye.
And for those of you who are here for my Shine Investments Matter at 10, if you'll give me a few minutes to get some fresh coffee, I'd appreciate it. I'll be right back with you guys at 10 o'clock. Okay. Before we go on the record, Madam Court Reporter, in the before we go on the record in the Shine matter, I just need to put a pin in a couple of things that were on my 9 o'clock calendar. So if you'll just give me a moment. Mr. Freehoff, no one ever appeared in position 3, Capital One versus Pamela Crutcher. I think you were going to check and see if anybody opened the notices.
Yes, Judge, and I apologize for my voice. I've caught a chest cold from the toddler. Someone by the name of Andrew Melhorn, who is not the person who signed the petition, but is listed as additional counsel under the signing attorney, opened the notice on October 28th at 1:12 a.m. Eastern Standard Time. So that firm did have notice of the hearing and no one showed.
Okay, pursuant to the notice and our procedures, please dismiss that case for lack of prosecution.
Yes.
And then regarding position 4, Amir Navabi versus Patrick Smith, no one ever appeared. Any indication that anybody opened it?
A little trickier. No, no one ever opened it. Of course, it was mailed to defendant, but Amir Navabi filed his petition at a kiosk in the clerk's office. As you know, our standing order, which generally echoes the standing order of the clerk on e-filing, states that anyone seeking to file documents without using e-file must complete and file a sworn certification that the person has no email address. I looked at Mr. Navabi's originating petition. It does not make such a certification, and no other document of that nature was filed into the record at any point.
I will also note that my review of the file gave me concerns because the notice of service of process indicates that the defendant was served at the courthouse, which is unlikely and potentially improper. And so under all of those circumstances, I'm going to dismiss that case for lack of prosecution as well.
Understood. Thank you, Judge.
Thank you, Mr. Freehoff. Okay. Ladies and gentlemen, Madam Court Reporter, we are going to go on the record in the matter of Shine Investments versus the City of Atlanta and Kisberg Construction. If I could get announcements for the various parties in terms of who represents Shine Investments in this matter.
That's me, Your Honor. Brian Henderson for the plaintiff.
Okay.
Also Tanya Tuttle, Your Honor.
Hi, Ms. Tuttle and Mr. Henderson.
My apologies, Tanya. I didn't see you on the screen.
No worries, Brian.
And who do I have here? I believe Mr. Ash, I have you here on behalf of the City of Atlanta.
I am Robbie Ash, and I am here on behalf of the City of Atlanta.
And let's see, I also see Mr. Varghese. Did I pronounce that correctly?
Varghese, Your Honor, yes.
Varghese, and you're here also on behalf of the City of Atlanta, correct?
That's correct.
Okay. And if you could mute again so we can get rid of that awful feedback. Thank you for answering my question. And Mr. Sellers, are you also here on behalf of the city?
I am, Your Honor.
Okay. Okay. So the reason we're here is because this matter is set for trial in November, after an original default judgment. It's set for trial on damages associated with the demolition of a building. Mr. Ash specifically requested this hearing on a motion to reopen discovery, potentially to accompany that with a continuance of the trial date. And it seems as if the more concise issue that I think Mr. Ash wanted to bring to the court's attention, if I understand the email traffic that's gone back and forth, is that as part of an effort to resolve the case, I don't know if it was formally a mediation or not, that there had been some, I think Mr. Ash characterizes as an agreement to produce additional information in exchange for not pursuing certiorari relief in the Supreme Court, and that upon dismissing the appeal and returning to the trial court, the Shine Investments have declined to provide additional information. Of course, discovery is long closed. And so absent an agreement among the parties, or an order by the court allowing for some reopening of discovery, then we will be going to trial in November with very little information, it appears. But I'm gonna hear from everyone. I start with that, Mr. Ash, just to sort of let y'all know that I think I'm aware of what the issue is that brought us here today. And Mr. Ash, if you will just take it from there, because technically it is your motion, sir.
Thank you very much, Your Honor, and I appreciate that. You have summarized the issue. You know, I want to start by saying I appreciate the court hearing us on an expedited basis. We were very recently retained by the city to take over the defense of this matter. And specifically, we were retained after an unsuccessful mediation, and it was a formal mediation on September 19th, following the entry of the Court of Appeals opinion. And I'm not today going to go into the substance of the exchanges between the parties at the mediation to preserve what remains of its confidentiality. But it shouldn't surprise the court that the parties fundamentally didn't agree on what plaintiff's damages were. But instead of giving up, the parties walked away from the mediation with a set of agreed upon next steps that were facilitated and recorded by the mediator and confirmed in writing by counsel for both sides. That agreement and the plaintiff's counsel's expressed consent to that agreement is attached to our motion as Exhibit 1. We are here today because after having received the benefit of the bargain from the city, the plaintiff has now chosen to renege on its commitments to the prejudice of the city. Specifically, the plaintiff asked the city to dismiss its cert petition regarding the Court of Appeals ruling, and in exchange, the plaintiff said it would produce documents to help the city understand its damages figures. With trial looming, the plaintiff surely knows what evidence it intends to introduce to prove its damages. So that's effectively what the city has asked for. Give the city documents that would allow us to understand why your damages number is significantly higher than we think it should be, both to help inform a possible second mediation session and to prepare for trial. And that's in essence what the plaintiff agreed to produce by September 26th, if the city dismissed its cert petition by September 23rd. And on September 23rd, the city upheld its end of the deal and dismissed its cert petition. That voluntary dismissal is attached to as Exhibit 2 to our motion. September 26th then came and went, however, with no documents, not a single one from plaintiff nor any explanation. Importantly, and if you're wondering why we waited until October 15th to file this motion, in conferral discussions between when we were hired, which was the Monday following the 26th, or when we appeared, and October 13th, we were told that they were compiling the documents and or considering specifically what to provide. It was not until October 13th that apparently, and I assume it's the client, not the lawyer, I don't know for sure, but I'm assuming this is a client issue, that they decided to renege on the deal and told me in a call that we wouldn't be getting any documents from them at all. No explanation of why, just a flat refusal. So that's why we didn't move earlier. And also why plaintiff's change of heart is so prejudicial. They ran down the clock, even after they let the city uphold its end of the bargain and dismiss its cert petition on September 23rd. And then whether intentionally or not, Shine strung me along. And only on October 13th did they effectively force our hand on this. I suspect opposing counsel may say that his client changed his mind after we got hired and we got a continuance. But aside from the fact that that isn't a term in the deal in Exhibit 1 that he signed off on, you should know that plaintiff actually asked the city to agree not to seek a continuance in exchange for getting those documents, and the city declined. But Shine entered into this deal anyway. So the fact that after the deal was struck and after the city complied with its piece of the bargain, then the city hired new lawyers and we asked for an extension per our statutory opportunity, that's not any excuse at all, let alone a legally sufficient one. Had the plaintiff simply done what it agreed in writing to do, in explicit exchange for the legal detriment by the city, dismissing its cert petition, we'd have had their damages evidence more than a month ago. We'd have been able to give them to an expert to have them come up with a evaluation of the property at issue, the building at issue. But we haven't been able to do that because we don't have a single document. So that's essentially what we're asking you to do now. Give us the benefit of the bargain, enforced against the party that accepted the benefit of the city's actions, but then belatedly refused to honor its own commitments. We ask the court
Mr.
to
Ash?
order them. Yeah.
Sorry to interrupt. Here's my question, and I don't know exactly what I might hear from Mr. Henderson or Ms. Tuttle in just a moment, but I'm assuming that there's at least going to be some argument, regardless of any agreement, that long before your firm was involved in this case, there was, I think, an original scheduling order issued by the court and 2 amended scheduling orders that allowed for discovery, and then a timely motion for summary judgment was filed and then ultimately partially granted. And that the appropriate time for securing the information regarding the alleged damages from Shine, as to the destruction of the building, would have been in the course of discovery.
And that certainly would have been true. And there would have been other avenues that could have been pursued in that discovery as well. We were not involved. I can't speak to why they did not occur. What I can speak to is that in the mediation, which we were not involved in, we got hired after the mediation, but they struck a deal. Plaintiff and the city came to a deal. You dismiss your cert petition, we'll give you documents. Because the city is, look, I'm going to be candid about this. We recognize we're behind the 8 ball, right? We're going to, if the current schedule holds, we're going to go to trial, and it's going to be trial by ambush, right? It's going to be pure cowboy style, and it's going to be nuts. My firm does a lot of things, but we try not to do things like that.
Yeah, well, we all try to avoid those things, Mr. Ash, definitely.
And so we're not here asking you to reopen discovery for all purposes. There is nothing before the court this morning that would justify doing that. What we have asked is instead, it's 3 things. 1, ask them to produce the documents that they may or will use to establish their damages at trial. They surely know what those are. Tomorrow, opposing counsel has told me that tomorrow he will send me his draft of the pretrial order. He will identify those documents in that draft. They have a list. We're just asking you to accelerate their production so that I get to see them now as opposed to at trial. The second request, and this does go outside of the scope of their agreement, or the scope of the agreement, but it is the benefit of the bargain, because we should have had a month, more than a month now, with those documents so that we could hire an expert. And let me stick a pin in the expert question, because I need to come back to that. But we would have been able to understand why our damages numbers are so different from each other. And then the last piece, so it's the benefit of the time, and we're not asking for an indefinite extension. We're just asking to be taken off in November and put in December instead, put on the December calendar instead. And then the last piece is also a de minimis burden to them, which is we would ask permission to take a 30B6 of the plaintiff limited to damages only after we have the documents. There again, they are preparing their client to testify in front of a jury in November about what their damages are using the documents that we're asking the court to order them to produce to us. So I guess it's a he, whoever the CEO of Shine is going to have to testify about it. We'd like an opportunity to take a couple hours worth of deposition of him on those damages documents so that we can understand them, we can understand how they'll be used. It will greatly facilitate having an orderly and less contentious trial. Ultimately, if we can't come to an agreement voluntarily based upon a better understanding of what the claims are, those are the 3 things that we are asking for. And let me come back to that thing I said about the expert. We do not currently have one, because one of the problems we have is we don't have any documents from the plaintiff about what their damages are. And so coming up with getting someone to appraise something sight unseen without any information about it is, as you might expect, quite difficult, at least to get a credible one. But I reached out earlier this week to confirm that the expert that the plaintiff is going to use is the person they disclosed to the city back in 2024 and was told, no, they're going to use somebody new. Plaintiff's counsel didn't tell me who the new person will be. Presumably, I'll find that out in the draft of the pretrial order tomorrow. But it's been my experience that if someone discloses an expert late like that, well after the close of discovery, a new expert, particularly when it's a replacement, you would offer us the opportunity to depose that person in advance of the trial. And so I think we're going to have a deposition on damages anyway with that new expert once they disclose it, once it stops being a secret who they are. So the idea of having their client prepared to testify about it, which would have to happen if we have a jury trial in November anyway, isn't a significant additional burden for them. I think it greatly would facilitate the truth-telling, the truth-seeking function that trials are supposed to be. And those are the three things that we would ask for from the court. I'm happy to take whatever questions the court had. I greatly appreciate the court's time this morning.
No, I think you have addressed my questions and laid out what the request is and the basis for it. So you will get the last word because it's your motion, but now I'm going to hear from counsel for Shine. Mr. Henderson?
Yes, Your Honor.
Go ahead.
Your Honor, there are a number of points sort of contention here, and kind of here's the roadmap for how I think we should consider them. First, I want to talk about the mediation and what it is that we actually agreed to at that mediation. Then I want to walk through why that agreement was made, what the other terms that have not been discussed so far in today's hearing are. I want to address why we made the choice not to disclose further documents. And then I want to move towards sort of the issue of, once we've sort of moved past enforcement of the agreement, this issue of reopening discovery, trial by ambush, and what information it is that the city actually has a right to and needs. So with that, Your Honor, this was a court-ordered mediation. We were required to mediate this issue. Initially, we were required to mediate it shortly after the granting of our motion for summary judgment. At that point, though, counsel on the case for the city didn't respond to our requests for a mediation date. They refused to schedule mediation during the pendency of the appeal, and so the matter sat open until remititure. Once the case was remitted and set for trial, we reached out to prior counsel for the city and said, "Hey, we need to have this court-ordered mediation. Let's get a date." We were at that mediation, Your Honor, from about 10 in the morning to almost 6 o'clock in the evening. And I want to address real quick the point about sort of mediation privilege and where that comes into play. And I do plan to address what was discussed at the mediation. I plan to do that, Your Honor, under the waiver of privilege as it relates to 917.3 and 917.4. The mediation privilege is a shield. It's not a sword. You can't go to mediation, engage in misconduct, and then come out and say, "Oh, well, mediation privilege, you can't talk about anything that happened there." It may not be as misleading.
Mr. Henderson, forgive me for interrupting you, but before we go down that very thorny road, right?
Yes, sir.
Let me ask you a more practical question. Mr. Ash has alleged, separate and apart from any agreement that the parties engaged in at the mediation or didn't agree to in the mediation, that y'all intend to produce for trial a new expert who was not disclosed during discovery. And I guess my question, I think Mr. Ash correctly points out that if that is a correct factual statement, that the case law is pretty clear that the remedy for that is is not, you can't have that expert, right? Although it frustrates the court endlessly when that occurs. But the remedy is go depose that expert. If I think the reason that Mr. Ash is pointing in that direction is if that is correct, what harm is there in reopening discovery on that limited issue if functionally Shine is doing the same thing by now changing to a new expert?
Yeah, Your Honor. So the answer to that question is this: disclosed in discovery, how? would be my question to the city, because the city never served any discovery. We didn't have to disclose an expert in discovery because the city didn't bother to ask a single question in discovery at all to Shine Investments. No discovery was served. So it's not that we're suddenly springing a new expert on them after we disclosed an expert in response to their questions. They never asked any questions. And that goes to sort of the broader point of why we're here, Judge. This is not a situation of trial by ambush. We didn't wait and hide our evidence and set some sort of trap for the city here. The city's had this case for 848 days, Your Honor. 848 days the city has known about this case. They've known the facts. They've known what was alleged. And through the city attorney who initially represented them, and then through private counsel with Mr. Schneider at Taylor Dumas, no discovery was served. Mr. Schneider even recognized in one of the filings in this matter that he came on shortly before the close of discovery, knew that it was running, and chose not to serve any discovery. The fact of the matter is the city just has not treated this case seriously for more than a year and a half, and now they're coming to the court and saying, well, we should get to do discovery now because now it's serious. We were wrong about the facts.
Okay.
And so I don't think that they are entitled to any sort of continuance related to our provision of an expert because they didn't bother to ask the question. We're not changing the terms that existed or the set on the field. They never bothered to ask. They didn't do their diligence and didn't do discovery.
Okay.
I understand the court's reluctance for me to discuss mediation, and if the court is at this point not inclined to enforce the mediation agreement, I'll happily skip that portion.
No, it's not that I want you to skip it. It's that my inclination as a judge is always to find the less thorny way to resolve an issue if I can. And so that's why I asked the question about discovery. But I think whether it is outcome determinative or not, you have at least made your point regarding that perhaps that's not the easy solution that the court hoped it might be. Go ahead, Mr. Anderson.
Your Honor, on the point of mediation, so this is a court-ordered mediation, I think at that point, nearly 800 days into the litigation. At that point, we've been through the close of discovery. We have been through motion for summary judgment. We've been through motion for supersedis bond where we laid out our damages. We've been through an appeal to the Court of Appeals. It's not a new case for anyone. Everyone's been involved for quite some time at the point we reach mediation, and we're there for an entire day. During that time, no offers are exchanged. Not a single offer has ever been made by the city for damages in this case to Shine in any amount. And I'm not discussing that to discuss settlement negotiations, Your Honor, but to show the lack of seriousness with which the city has treated this case for a year and a half. Counsel for the city showed up to the mediation unaware of facts that had been previously not only disclosed to them, but discussed with them in hearings. Counsel for the city arrived, according to their statements to the mediator, unaware that these buildings were finished at the time they were demolished, unaware that they had been permitted and only were a week out from certificate of occupancy. And at that mediation, the city had, the gall to request documents from us that were documents issued by the city. They said, well, can we see the permits that the city issued? Can we see the liens that are on the property? Can we see the deed records? The city came into this treating it with a total lack of seriousness, despite having fought us at every point of this litigation. They fought whether or not they could destroy the second property. They fought whether or not summary judgment was appropriate despite not responding. There has not been, they fought posting a supersedis bond. There hasn't been a single action taken by the city where they didn't fight tooth and nail against the claims of Shine. And they were doing all of this apparently without any real thought or preparation. And that's extremely frustrating to Shine. Not only did we spend the money for 3 attorneys to be there literally all day, but there were no substantive discussions because there couldn't be because the city hadn't bothered to do discovery. We ultimately reached the agreement we did, Your Honor, to try and salvage something from that day of mediation. And I want to go through what exactly it is that we did agree to. So you've heard that we agreed to provide documents to the city about our damages.
In
But I
your
want to-
discretion.
Absolutely, Your Honor. Documents at our discretion and documents that would be provided potentially after a list was submitted by the city. We did receive on time the list from the city, Your Honor, and the majority of things it asks for are things that the city has some other ability to access. It wants lien information, which of course is recorded with the city. It wants permit information, which is recorded with the city. You know, what we discussed providing was some sort of, and these are through the actual discussions with the mediator and with counsel, some sort of summary that would allow them to have an idea of what we believe damages to be, but not to provide all of the supporting documentation for that, not to provide original evidence, to give them some idea of what we believed our expenses to be, our damages to be. And so the question was then, well, why? And you see from the agreement that we were potentially going to have another sit down with the city, another mediation. But there's a step in between there that's not captured in the written agreement, but was part of an oral agreement with counsel. And that part was that the attorney representing the city attorney who was assigned to the matter, the mediator, and the city attorney would all have a meeting post-mediation and prior to the pretrial calendar. And at that meeting, the mediator would help explain our position on damages and help us get to a position where there could be some offer that would potentially get us back to mediation. And this is a time is of the essence sort of deal. It was supposed to happen prior to the pretrial calendar. We didn't want to delay the case any further. We made that very clear, and counsel's correct that we discussed the issue of whether or not the city would agree not to ask for a continuance. They refused to do so, but they understood that time was a factor here, that we were providing these documents only because we wanted to quickly have a meaningful mediation. So that's why we made the deal that we did. I would submit that we don't have to provide any documents at our discretion at this point because we're not getting the benefit of the bargain. And I want to address that in two ways. One is that we're not getting what we were supposed to in terms of time, Your Honor. That's gone. We've already had to continue the matter. We're already a month past that point. And so the time benefit to us is gone. The benefit that counsel keeps pointing to is the withdrawal of the petition for certiorari. And I would submit to the court that that is something that has no prejudicial effect on the city. It has no value, really. The fact of the matter is that, as the court will see, we can submit an additional filing here, but when we initially objected to certiorari, we did so because the city asked for certiorari late. They didn't do so within the 20 days required after remediature. Their request to the Supreme Court was untimely, and under Supreme Court rules, by filing an objection on the timeliness, the Supreme Court had full authority to dismiss the matter purely on that procedural issue without any review.
Right, but it hadn't done so.
That's right.
And there is still at least, I mean, I'm not a huge fan of the efforts at delay, but there is a value to not being forced to go to trial immediately because the Supreme Court is deciding whether it will or will not deny certiorari based on an untimely application, which sometimes takes the Supreme Court a long time.
And that's true, Your Honor, but given the application and the time, there wouldn't have been, based on the timeline of when the court would have had to rule on that issue, there's nothing to suggest that by our trial date, they would have even had to issue a ruling on the certiorari matter. So it's a theoretical delay that may have existed. But beyond that, Your Honor, it's an appeal of a per curiam decision where the Supreme Court said this is such a clear, or the Court of Appeals rather said this is such a clear matter, we don't even need to issue an opinion. It won't have any precedential value. So I understand Mr. Ash's argument. And I guess what I would say is, if anything, if that removing that sort of certiorari has some value, I think it's negligible. And I think that is less valuable, if not equally valuable, to the quick meeting that we wanted, the meeting with the city attorney, the things that we can no longer get from the deal. I mean, it's just, there's no way to put it back together, I guess is my point. Beyond that, Your Honor, the city was aware that we hadn't provided the documents on Friday when it withdrew its appeal and moved forward in this fashion. There wasn't any surprise. We were still obtaining and compiling documents. We don't have any sort of situation where, Mr. Schneider, prior counsel, said, hey, we're in breach of the agreement. Hold up. We're not going to move forward. So I'm not sure.
The fact that, but I mean, forgive me, but I'm a little bothered by the argument that their compliance with the agreement is somehow that they're to be faulted for their compliance with what they believed was an agreement.
No,
I mean, they
I'm
reasonably
sorry,
relied on the agreement they believed they had. Okay, go ahead. I understand your argument.
No, I'm sorry, Your Honor. Maybe I didn't make that point clearly. My point is not that they should be punished for reliance on the agreement. My point is that the state of play was known, that we were compiling documents and would try and get a document provision to them, but there was no sort of objection, hey, we don't have the documents like we're supposed to on Friday. We were working to compile documents that were still being provided that we thought would be able to meet this request from Mr. Schneider.
So,
That's it, Your Honor.
Mr. Henderson, to put a fine point on it, what is it that you were working to compile, and what is it that you did or did not provide? I think that's part of what I mean. I understand that the moment I saw that agreement and it said in my discretion or in our discretion or its discretion, I was like, well, okay. But I guess my question is, what is the what exactly is it that you believed you were compiling that you then did or did not provide to the city?
A summary of damages, Your Honor.
Okay. Mr. Henderson, I apologize for interrupting you. Now, I've just asked you a question. Can I have like a 2-minute break for just 1 minute? Sorry for the interruption.
Absolutely.
Sorry for that interruption. Thank you for the brief pause, Mr. Henderson. If you want to continue, you were starting to explain that what you were compiling and had believed that you agreed to produce was a summary of damages. Go ahead, sir.
That's correct, Your Honor. And the reason I believe that's what we intended to produce, or why that I know that's what we intended to produce, is we had given the mediator a summary of damages as part of our mediation brief, and he was using it in discussing the amounts with the city. And the city inquired if they could have that brief or that summary. I just probably know they couldn't have that summary, but I think we could probably edit it in a way that was something we could turn over to suggest approximated damages in different categories. We were debating internally with the team to what degree to turn over additional documents to sort of support the analysis in the summary. But a lot of that discussion, Your Honor, focused on kind of whether we thought the city would actually take any sort of real action on this matter. Again, sort of the pulsing kind of strobe light at the back of everyone's vision in this was that there'd been no offer extended to this point in this case. And there was a real feeling that whatever we turned over probably was not going to lead to an offer. It was probably simply just going to be used to augment discovery, but we were going to try and get to that point as we could. So I would just reiterate, Your Honor, that I think we don't have to provide any documents under the agreement. It says at our discretion. Beyond that, I think that if we were to provide documents.
Is it fair that you don't have to provide any, or is it fair that I guess if you agree to produce documents at your discretion, I would definitely agree with you that that language gives you discretion about the scope and scale of what is produced, but it does assume that something will be produced.
And I agree, Your Honor. And it was our intention to produce something, but then the deal changed in a way that affected us. So what happened is, as soon as we got the notice that new counsel was coming into the case, we said, okay, well, how does this affect the ongoing deal that we have? Now, I'm in the UK at this point during the timeline. So I'm doing things on sort of a different actual time scale. And we had discussions with new counsel for the city. And I want to address this idea that no explanation was given for why nothing had been produced, because that is not my recollection. And I specifically remember making comments in the discussion contrary to that, which were that we weren't sure there was any value to production at this point because the city confirmed that they could not meet the other terms. They would not be able to have a meeting with the city attorney prior to the pretrial conference. They knew nothing about the agreement of the mediator to step in and have that meeting and sort of use his credibility as a method for furthering negotiation.
Sorry, I don't want to get distracted by things that are potentially extraneous, but did you say that the city wouldn't be able to have a meeting with the city attorney?
Not within the time frame. That's correct, Your Honor.
And what was that time frame?
That it was supposed to be prior to the pretrial calendar.
Which is in November? Or is this before I had moved it?
Before you had moved it, Your Honor.
Okay, thank you.
And so at that point, we were told, no, there's no way we can come up to speed quickly enough. We can't have that meeting within the time frame. And I don't know if the court followed the email traffic, but that's the point at which I sent an email to the court, saying we don't object to this continuance for Mr. Ash. We understand he's got family obligations, but we do object to the substitution of counsel here because they can't fulfill the deal if they're substituted. So at that point, we were still willing to engage in the deal. We were still willing to provide documents, but we said, hey, it's not fair to change counsel at this point if new counsel can't deliver on the deal. And the response in that email traffic was basically, well, there are lots of other reasons to continue. That's not some sort of binding point. And counsel shouldn't have to be locked into that. We couldn't oppose the substitution of counsel. And so,
well, to be clear, if I'm recalling correctly, not that I mean to discount Mr. Ash's, familial and travel obligations, which I always try to be very cognizant of because we all have them and we all ought to be able to participate in them. My recollection is the only reason that I granted that continuance was because Mr. Ash correctly pointed out that he was statutorily entitled to one. And so because of the remitter. Yeah.
I apologize, Your Honor. I didn't mean to interrupt the court.
No, that's okay.
It's not an entitlement.
Right. I mean, I understand that, but there was a basis for it given its remitter. And so that's why I granted it. I remember not being particularly concerned about allowing the substitution of counsel because Mr. Ash and his firm may not enjoy the expedited process, but are quite capable of getting up to speed as they need to. And I'm certain that they will whenever this matter goes to trial, assuming that currently it's set to go to trial in November. So go ahead.
Yes, Your Honor. And I understand. I'm not at this point objecting to the substitution of counsel. I'm simply saying that we said we still want the benefit of our bargain, which is a sit down within X time frame, and the dates were all in the agreement. If that's not going to happen now, why should we provide the documents? The purpose of the documents was the expedited sit down. Counsel says there can't be any expedited sit down. well, why provide the documents? If the court does want us to provide some damages summary, like what we gave to the mediator, we can put that together. I mean, I don't object to doing that because, quite frankly, I don't see it as a sort of backdoor of reopening discovery, which I think a lot of the rest of this is. But that's why the terms were what they were at mediation. That's why the agreement that was made was made. You know, we asked to address this issue previously and asked to have a hearing where we would be able to contest the continuance and or the substitution. And you know, the response of the city at that point was, well, no, there's no prejudice. There's no reason to do that. We shouldn't be able to prevent substitution, you know, even if it's going to sort of scuttle the deal. Beyond that, Your Honor, I want to sort of move to the trial by ambush point that we discussed earlier. This isn't trial by ambush. It's not an ambush if the other side doesn't use any of the tools at their availability for a year and a half. We're not the reason the city doesn't have discovery. The mediation is not the reason the city doesn't have discovery. Any change to the agreement is not the reason the city doesn't have discovery. They don't have it because they didn't bother to do it. And I want to be very clear about what's being asked. The city is now asking the court to impose tremendous cost on the defendant. I'm sorry, not the defendant, on the plaintiff a year and a half into this litigation to comply with this new discovery that they're not entitled to. They want a 30B6 deposition. They want limited access to written discovery. They want an expert deposition. They've also filed notices of trial deposition, Your Honor, at least 2 out-of-state notices of trial deposition. So they want the court, and we'll file challenges on those as well, Your Honor, but they want the court to force us to fly our attorneys and our client out of state to sit for a deposition that they could have noticed if they chose to during the actual discovery period.
Well, I mean, they are entitled to do that type of trial preservation of evidence. I question whether it's necessary in this day and age for anybody to get on a plane to go anywhere and do anything for a deposition, certainly. But the fact that they're engaging in pretrial preservation of evidence, pretrial compulsion of evidence, I don't necessarily think is improper or is overly burdensome, given that it is certainly within, you know, it's authorized and routine to engage in those things. It's just usually not as a substitute for discovery that hasn't already been done.
Absolutely, Your Honor. And like I said, we'll address that issue more in our challenges to those subpoenas. But it's extremely frustrating to find ourselves a year and a half into this case where we've just begged and begged and begged to get a settlement offer, have never received one. The city's not treated it seriously for a year and a half, and now they're saying, well, oh shucks, we should be able to reopen discovery. And I don't understand why. There's no good cause that has been shown. The fact that the city's unprepared is not good cause without some demonstration of due diligence. And there's no due diligence in the record here, Your Honor, not a single bit. It's just, I think that the precedent it sets, the message it sends, not only to the city, but to other litigants to reopen discovery a year and a half into this matter when nothing was done, is that there's no point in treating plaintiff's claims seriously until you're on the eve of trial, and then you can just continue everything and drag the matter out for that time and force costs on them. The last thing I want to address, Your Honor, is this sort of contention that the city continues to make that they just don't know how to value damages. They don't know how to make an offer. And I think that's kind of a ridiculous contention given the access to evidence that they have independent of any reopening of discovery and independent of any deposition of the parties in this matter. The city knows what the properties were worth. They know what they were sold for. They know what they were auctioned for in foreclosure because both properties ultimately went into foreclosure. Those are all publicly available. They know the lien amounts from the contractors on the properties. Those things are all publicly available and were filed. They know everything they need to regarding the permitting, which, as the court may or may not know, when you're listing your permits and your applications, you're listing out the pricing of things, you know, how many bedrooms, how many bathrooms, what sort of things were installed, where they were installed. These are all things in city inspection reports they can value.
I mean, isn't typically a permit, isn't it a percentage function of the cost of the overall project?
Yes, Your Honor.
Okay.
And so these are not numbers they can't somehow access. They just still haven't. And I'm not faulting Mr. Ash for that. I mean, it's not their fault they haven't done it yet, but they can figure out damages. They can also figure out damages from the record in this case, Judge. The anti-litem notice outlines damages as they were at the time. The motion for summary judgment outlines damages in detail. The motion for supersedis bond in particular outlines the damages by building, what the cost to buy were, what the value at demolition was, what the estimated cost of construction were. I mean, everything the city needs to make a reasonable argument, a reasonable valuation of this case is available to them. And the things that they're seeking in reopening discovery ultimately don't affect the valuation. They just don't. We could reach a value number based on publicly available information without any need to reopen discovery. And so I just don't see that there's any necessity to do that. If the city...
Let me ask you a question, Mr. Henderson.
Yes, sir.
Setting aside for a moment whether or not to reopen discovery is a matter, as I understand it, that's pretty well soundly within my discretion.
Absolutely.
And one of the things I am curious about is the extent to which, if the court were inclined to in some form reopen some limited discovery, which I think would necessitate moving the trial, where is the prejudice to Shine Investments? Assuming for a moment that that's a relevant consideration for the court, where is the prejudice to Shine to, 30 days of a delay for a trial in December, for an opportunity to avoid what, the entire Civil Procedure Act structure is made to avoid, which is trial by ambush?
The prejudice to the defendant is a couple-fold, Your Honor. One is
the plaintiff?
I'm sorry, Your Honor, the plaintiff.
That's okay. I do it all the time. Go ahead.
I was a public defender for too long, Your Honor. I just naturally default to the defendant on everything.
Sure.
But there's a number of areas of prejudice, Your Honor. One is the continued delay of this case, which we've asked multiple times not to be delayed. We were told the last time this would be, we just needed a single continuance to get up to speed after remediature. This is not a big deal. And here we are with, well, no, actually, we need another month. So I think there's the continued sort of delay issue.
Well, in fairness, I'm not sure that Mr. Ash necessarily is taking the position that he needs another month. He's taking the position that he needs discovery. And if you could somehow, if I could wave a wand and somehow provide him with that discovery right now, I'm not sure that Mr. Ash would say I absolutely can't go to trial in November.
Understood, Your Honor. I think the second area of prejudice is that the costs have accrued in this litigation the way they have because the city refused to engage in a meaningful process. And there should be a consequence to that. It's not like this is a situation where the city came in at the beginning of this case and said, gosh, we would knock down this building with an expired permit. We're clearly liable. Let's get to the heart of this and talk damages. As I've outlined before, we've had to fight through every single inch of this case. And we've had to do it without, we've had to develop a litigation plan and execute that litigation plan based on the circumstances as they were on the ground, which involved the fact that there was no provision of discovery. That affected how we approached the case, how we approached the litigation, the motions for summary judgment, all these other portions of it, and costs were expended there by the plaintiff based on the situation. I mean, again, things like the summary judgment, the challenge to it, the challenge of the supersedis bond are all costs we incurred, it seems to me, because they didn't engage meaningfully in discovery. And there's no... That price was paid to put us where we are, which is the ability to go to trial with the evidence as it is. And so I'm just not particularly, not that persuading me is the test here, Judge, but I'm not particularly persuaded by the argument that there's some prejudice to the city. The city didn't do what they were supposed to.
Okay. What about Mr. Ash's point? I'd like for you to respond, please, to, it is October the 30th. We are set for a pretrial conference on November the 5th, I think. I can't remember the exact date, but I know it's next Thursday. Maybe it's the 6th. And in an effort to compile an agreed consolidated pretrial order to submit to the court, which I think is due on Monday or Tuesday, you're necessarily going to have to identify documents that you would plan to use in trial. And I guess where is I assume you're planning to do that, correct?
Yes, Your Honor.
Okay. And I guess my question is, if it is pretty standard practice in any lawsuit for me to require the parties after a CPTO to engage in a meet and confer to decide if they agree that the documents can come into evidence, all of that presupposes that at some point prior to the November trial date, which I can't remember if it's the week, it must be the week right before Thanksgiving. Because Thanksgiving's the last week of the November this year. Okay. That would necessitate you providing the city with a copy of that information that you intend to rely on and to present at trial in support of your damages, would it not?
It would, Your Honor. And
Okay.
I see the court's, I apologize.
No, go ahead.
I understand the court's question. What's the harm in just giving it to them early?
Mm-hmm.
And the answer is it's not just giving it to them early. It's a different document set than it would be if discovery is reopened. It's not like we're making these decisions in a vacuum and our litigation strategy doesn't change based on how the city is or is not prepared.
Mm-hmm.
And so the evidence that we would use in the trial as it stands may well be very different from the evidence we would use if discovery were reopened. And I can say for a fact it would be different because there certainly be different witnesses we would need to call in the event that discovery is reopened and the world of evidence changes from what it is currently, which is another area of prejudice to the defendant or the plaintiff in this case, Your Honor. I mean, we're too far in. We're way, way, way too far in to reopen discovery and force Mr. Poole, who is the principal of Shine Investments, to incur additional costs to litigate this case beyond what should have happened already. I mean, we're talking about new depositions, we're talking about new written discovery, we're talking about redoing planning regarding the pretrial order and our witnesses, figuring out new people we may have to subpoena. It's a tremendous cost to now impose on the plaintiff at this point. And I don't see the reason for it. If the issue is time, Judge, if all they need is time, I have no objection, pending sort of the other parts of this, to this being removed from the November trial calendar so they can get their ducks in a row and get the documents they need from other people. But I do have an objection to anything that's going to shift costs now and change and force a change in strategy to Mr. Poole, because I do think that is prejudicial. I don't think there's any justification for it here. And while the court certainly has broad discretion to make this choice, it is laid out what the court should look to. And one of those things is good cause. And good cause is when due diligence has been exercised and for some reason it hasn't produced the expected result. And that's just not what we have here.
Mr. Henderson, sorry. I do have one other question, and then I'll let you sort of wrap up before I call on Mr. Ash. And this goes back to the sort of original discussion about what the actual basis of this hearing was, sort of a motion to enforce a mediation agreement associated with some production of documents. And I think I understand your argument to be that there wasn't really an agreement that could be enforced, or if there was, some of the requirements of that agreement in the form of that subsequent meeting that may or may not be written down as a part of that agreement wasn't performed, and therefore the rest of the agreement is unenforceable. Or if the agreement is unenforceable, the only enforceable aspect of it is to produce what you and your client in your discretion determined to produce. Is that roughly accurate in terms of your 1, 2, 3 responses to the motion?
Yeah, Your Honor, pretty close. I would say with the exception of the idea that we were still willing to follow through and participate in the agreement such as it was at the time that counsel substituted. We asked that not happen for exactly those reasons. we asked to move forward with original counsel so that we could get the benefit of our bargain. And the city's election was no, we're not interested in that. We want to move. The city wants both things, Judge. They want the benefit of the bargain they struck without giving us the benefit of anything that we asked for, that were sort of the time is of the essence and value clauses that made that deal worthwhile. And so I submit to the court that at this point, Your Honor, we're not really interested in sitting down for another mediation. We're not really interested in engaging in that process.
That may be fair, and I may understand why the parties may have no aptitude or appetite, I guess is the right word, for an effort to engage in further mediation. But to that point, I do want to follow up and make sure I understand one question. I'm not sure I understand your continued characterization that the Shine didn't get the benefit of the bargain. I understand that you sort of minimize the value of the dismissal of the certiorari petition. And I've looked at the bullet points that were submitted by Mr. Ash. And there is some discussion of like a later offer that has to be above a certain minimum and some things like that. Is that the part of it that you're saying you never got the benefit of that? Is that?
No, Your Honor. There were specifically oral agreements, which are binding on the parties, which were made at that meeting, that prior to the, what I can't remember the date, would have been in September, I guess, or October for the trial calendar, that a sit down would happen with counsel for the city, with the city attorney, and with the mediator, where the things we would have provided would be discussed, the mediator would be able to render his opinion, and that would all happen within, a sort of 2-week time frame, basically. It would all happen quickly. And that's the benefit of the bargain, that everything happens quickly. We don't delay things unnecessarily. The city was allowed to move for continuance, Your Honor, but we didn't agree to some sort of continuance, right? We made very clear that we would oppose any continuance. And so, we made a deal to try and expedite things. That can't happen now. In fact, we're being asked to delay things yet again. And so if the court wants to say, listen, they withdrew the petition for certiorari, so provided, a sort of best guess damages summary like you were going to initially, I understand the court's ruling. I don't think there's an enforceable agreement at this point. But that's not a tremendous burden to us. It's not going to be tremendously costly for Mr. Poole if we modify what we previously had and provide that in some way. But there is no ability to get the other benefits.
Okay.
And I'm sorry.
Go ahead. No, I was just saying, thank you. Go ahead. I think you've answered most of my questions. If you'd like to sort of finish what you were saying, in terms of wrapping up your argument.
No, I mean, I think we've sort of laid out the points, Your Honor. I guess the only additional thing I would say is that this is, I don't have a particular objection to time, if that's what the city needs. Ultimately, they need to remove this to the December calendar so they just have more time to collect the documents and get ready. Fine. That doesn't impose any sort of tremendous additional cost on Mr. Poole. But reopening discovery does. Especially if we're talking about a 30B6 deposition of Mr. Poole. We're talking about preparation, defense of the deposition. I mean, and we're doing all of that without any regard to the fact that we've spent a year and a half laying out our trial strategy here based on the circumstances on the ground. And so I just think that the sort of greatest cost to the defendant is we would be basically being told to redo our litigation strategy, redo all of our preparation, reconsider all of our evidence, and spend the time and money to do that at the last minute. And there's no justification for it. If the city had not received the discovery it asked for, if the city had, really done anything to exercise due diligence, I might feel differently. But a year and a half later, after doing nothing, I don't understand it. And the last point I want to make, Your Honor, I promise I'll stop rambling after this. It's just that this is not some new set of facts that the city was unaware of. There were substantive motions and hearings happening where either a deputy city attorney or private counsel was present, participated in oral argument, participated in briefing. It's not like the city didn't know the damages were going to be so high. They didn't know the buildings were finished. It's just not true. Those things were all known a long time ago to the city. And so it's not an emergency now just because, quite frankly, council who has a better grasp of what needs to be done has come on to the case.
Thanks, Mr. Henderson.
Questions at that point, Your Honor?
Okay. Mr. Ash, it's your motion, sir. You get the last word, although I might have a few questions as you go. Please go ahead.
Absolutely. And I thank the court for its time. Let me start with where the court started. Can we share a screen?
Sure.
Because, and I'm going to assume that since another lawyer for the plaintiff did this, Mr. Henderson was just unaware when he said they hadn't disclosed an expert. Here is the disclosure of their expert. And that was done on the 30th day of September, 2024. They formally disclosed Brian Penley as their expert witness. Jeffrey Schneider was the person who made that disclosure to the city. That's how I knew the name to ask Mr. Henderson about earlier this week, whether they were still going to use Brian Penley. And he said, no, we're going to hire somebody else.
Can you take down the share screen? You've made your point. Thank you.
Right.
And I suspect that was done in an abundance of caution, even though a discovery request had not been made, because the court had a deadline that said these are the dates by which experts need to be disclosed. So
Yeah.
go ahead, Mr. Ash.
Yeah, and so the next piece of this I'll say is, I think we may be talking past each other a little bit. We are not asking the court to reopen discovery for all purposes. We are not asking the court to reopen discovery even for any purpose related to damages. What my request was you order them to produce the documents that they may or will use to establish their damages at trial, which he's going to give me a list of them tomorrow. Right? I'm not asking to newly serve interrogatories. I'm not asking for, yes, we have served trial subpoenas because we have a statutory right to do that. And we absolutely will pursue discovery, we will pursue the information we need to try this case pursuant to our statutory right to do so. But what I am asking this court to do is simply give us the documents, make them give us the documents that they're going to produce anyway. They're either going to produce them at trial or they can produce them now. The second piece that we are asking, I'm not asking for a lot of discretion. In other words, Your Honor, I'm asking for a little bit of discretion. And again, the idea that we are trying to impose a tremendous cost strikes me as unrealistic because producing those documents is something they will have to do anyway. As the court noted, they'll have to do it as a practical matter before trial anyway if they want to have a meet and confer about those documents. They're going to have to prepare their witness to answer cross-examination questions about their damages. Whoever their new expert is, I think they're going to we're going to get to depose him. So all of these, again, the marginal incremental cost of doing that discovery in November and then having trial in December, they would have incurred those costs if we go to trial in November anyway. There's or at least there's very little. I mean, yes, I suppose if we do the 30B6, and I'm happy to do it via Zoom. I have no desire to fly to the Pacific Northwest, or if I do, I would want to do it in the spring or summer. I certainly wouldn't want to do it in the winter to take his deposition. And so they have to prepare him, but they're going to prepare him for testimony. So it's not a tremendous cost. It is I submit, pretty narrowly tailored request specifically for the information that will lead to a less contentious, less choppy, more efficient trial. It also may well help the city understand where we are. And so let me go back to this question of what was discussed at the mediation, what wasn't discussed at the mediation, and the benefit of the bargain. Because setting aside for the moment the idea that, the mediator put express deal points down. And opposing counsel said, yes, that's what we agreed to. He did not say, yes, that's what we agreed to, as long as we also get a meeting with the city attorney in the next couple of days. That's not what his email that is attached as Exhibit 1 says. But I think there's also something he said that they let the city on the 23rd dismissed its certiorari petition because on the 23rd, the city still believed they were compiling documents, that the plaintiff was compiling documents and was going to produce them on the 26th. So on the 23rd, the city did not know that the plaintiff intended not to produce those documents. And as far as I can tell, on the 26th, the plaintiff did intend to eventually produce them, but then got mad about the substitution of counsel and the fact that I said I can't have a meeting without documents at which I can advise my client what kind of offer to make. There's an inversion of the cart and the horse here. I am still willing, and I've said this to him separately, I'm still willing to get him a meeting after with the city attorney and the mediator. I'll stipulate to that again, but I've got to understand what we're working with. And so give us the documents.
Forgive me for interrupting, Mr. Ash, but one point that I do think Mr. Henderson, that I do credit to some extent is this is not the many types of cases we've all seen where the existence and understanding of the claim and the nature of the damages is entirely within the purview of the claiming party, right? I mean, the city not only has access to the real property that is in its jurisdiction, but I mean, this whole entire case started because the city was paying attention to the property and had ordered its demolition. And so the city had information given the age on that demolition order that resulted in the untimely demolition. I mean, we're talking 5 years ago, the city was aware, if I recall correctly, the dates of this building, of its condition. And there were, at least, even to my knowledge, there was evidence at summary judgment regarding the people who were sent to demolish it saying, hey, are you aware of its condition? And then the city saying, it doesn't matter, go ahead and demolish. Not that I don't bring that information up to indicate that it would be dispositive of an outcome here, but it is demonstrative that the city had within its purview lots of information about this property and its potential value, and the ability to inquire further about it inside or outside of the discovery process.
And it is absolutely the case that the city has information. Look, and if you tell me we got to come to trial in September or in November, rather, we will come with the building permit application. We will come with the appraisal that was done. We will come with, there are public records. It's not that we have nothing, but there was such a wild disjuncture between what was asked for at mediation by the plaintiff and those publicly available numbers. I'm trying to get a handle on where's the delta. What's the difference? What's the special sauce that accounts for that? Mm-hmm. And that's why if I had defended this case from the outset, we would not be having this conversation.
I'm certain that that's true, Mr. Ash.
Aside from perhaps this quibble about this new secret expert. And anyway.
Well, and let me take a moment to go on to that topic. I'm not sure. I think those are two different conversations.
Yeah.
And the reason I say that is you've made your point that they did in fact identify an expert. But typically the argument about a changed expert is, well, but we prepared our entire defense based on what this expert said. Yep. And what I haven't seen other than an identification by name is any information about what opinion that expert had, or what value that expert would place, or what qualifications that expert had. And so while I still might allow the city some limited ability to inquire with any new expert, the prejudice argument is a little off kilter here, because it's not as if the city can, in good faith, make the argument that they fully prepared based on what this expert was going to say. And now all of a sudden they've got a new expert who presumably has a different opinion, because y'all don't due respect. The city never really knew what that person's opinion was.
No.
And never knew what his qualifications were, and never knew what his opinion of value was. So go ahead.
And that's a totally fair point, Your Honor. And my point in raising the question of the new expert was, we're gonna need to get into damages discovery with that person anyway. We have done research based upon that identification. LexisNexis is a potential trove of information about what people who testify for a living have testified to before. So it's not, respectfully, and without going into our trial preparation, it is not the case that we have done nothing with that person's prior identification. But you're right, the city at the time didn't follow up on that. The point I was trying to make was this. We're really asking for pretty limited incremental information. We're asking for it a little earlier than the plaintiff would prefer to give it to us. But everything we're asking for, Shine CEO's testimony about his damages under cross-examination, the damages documents they intend to use at the trial, those are things that they are currently planning on providing in November at the trial. We're asking that they still be provided in November, but just in advance of the trial so that we can work this through. And so let me go back, though, to the benefit of the bargain, because I'm frustrated by this because we weren't present at the mediation. We weren't engaged for at the time of the mediation. So I can't speak to an oral agreement. I can say that my client's account of that conversation, those conversations, is different than Mr. Henderson's, but we're not putting on witnesses today. I'm not going to.
Well, let me save you the trouble there and say that I'm not going to get into whether those oral agreements were made or not made, but the traditional, I mean, I know there's not a merger clause and we don't have a formal agreement, but I mean, the traditional rules of contract here are if we make a list of the things we've agreed to, then in theory, that's supposed to be to the exclusion of other verbal things that we also agreed to but didn't write down. And so to the extent that the court is going to consider the nature of any agreement that was had, the court's going to focus on what was reduced to writing and not objected to by the mediator, as opposed to additional parole agreements that might have been made.
And I appreciate that, Your Honor. And yes, that certainly would be our preferred approach on that. I will say, though, that I think where that leaves us, and the court correctly noted that this says you will provide documents at your discretion. I mean, it did not contemplate they would provide nothing because they got mad that we wouldn't have a meeting with them before they gave us documents, because they were going to give us documents on the 26th and then chose not to do so. But for 2.5 weeks until October 13th, we still understood that they were compiling those documents. It wasn't until the 13th that they told us they weren't going to provide any of those documents. I'm still willing to sit down. I mean, maybe they don't ever want to talk to us again. Maybe the next time we see each other is when we walk into, what are you, 4B?
Yes,
into the back of 4B. And that's the next time we have any conversation about resolving this case. That seems like a shame to me. But I can't give my client an opinion about what their liability here is without knowing without knowing a little bit more. That's what I've asked for. We've offered to give them, even assuming there was an oral agreement, and I contest that, if assuming there was, we'd still give them the benefit of that bargain, but they still have to uphold their end of the deal, which is provide the summary even of the documents. And then here's my point about the limited incremental difference. And why I think that there is good cause is if they're going to provide a summary of their damages, like line item, line item, line item, all we're asking for is at trial, what is the document or what are the documents you think add up to that number? What are the documents that add up to that number? What are the documents that you think add up to that number? You don't have to give, I'm not asking for emails. If the emails aren't documents that you were going to rely on at trial, I would have if we had done discovery. But I know where we are now. That's not what I'm asking the court to order today. I'm asking the court simply to say, enforce the benefit of the bargain, to give us the summary if that's really all they were going to provide. Although I think they were going to provide more than that because that would help substantiate the summary. Provide the documents that they intend to rely on at trial, and then allow us to take a 3-hour Zoom 30B6 of the plaintiff so that we can understand that. We'll cross the bridge with the expert when we have to cross the bridge. Because I guess we're going to have to get an expert too, but it certainly will help if we have some documents to give that expert so that they can have an opinion that's not more than, well, I went and walked around and it doesn't look like much. I'm happy to answer any other questions the court has. I deeply appreciate the court's patience and, again, handling this on an expedited basis.
Okay, thank you.
Your Honor,
Yes.
I know I can't resist pushing the limits of the court's patience. I just want to address just one thing, Your Honor, because I want to make sure there's no misunderstanding on this point. We keep talking about us providing the documents that we would use at trial, or those documents, or Mr. Ash said, well, clearly they'd have to call Mr. Poole, so why is it necessary?
Mr. Henderson, forgive me for interrupting you, but that you're not adding value to what I was about to say. So no offense. I don't mean that as a slight in any way, but I don't know that I know we as lawyers always want the last word, but I don't know that it helps. So I'm going to ask you to stop.
Understood, Your Honor.
So to me, what as I mentioned a moment ago, what I'm looking at is what agreement did the parties enter into, and problematically or otherwise, right? There is, the nature of the agreement prioritizing what was reduced to writing by the mediator, and again, not objected to by the parties, is that the plaintiff agreed to give a cursory list of described damages to the defendant, with the content being in the discretion of the plaintiff. And then the plaintiff agreed to provide some documents in its discretion in relation to showing its damages. And that, even if the plaintiff disagrees as to the scope of what it would have produced and what in its discretion and cursory mean, which I agree are significantly significant limitations, but those words, while they might be limited in the discretion of the plaintiffs, do in fact presume and suppose that something will be produced, the scope of which may be within the discretion of the plaintiff, number one. I don't see anything in that agreement that implies that that agreement is contingent on any other agreement, any other parole agreement. And while the plaintiff may discount the value of the consideration that was offered here, which was the dismissal of the petition for certiorari, I think there was an agreement, at least to that limited extent, and that the plaintiff ought to perform on that agreement. But that's an easy decision for me to make, and here's why. At the end of the day, even if the parties have not engaged in discovery, the court requires that the parties meet and confer in advance of trial so that when we are actually trying this case, it is not a complete ambush. And not because the defendant has some right when, no offense to Mr. Ash and his firm, but the city declined to engage in discovery. And so normally the purpose of a meet and confer is that the parties will have engaged in discovery. They'll have an idea of what the universe of documents is. And I ask them to engage in that exercise so that we can avoid the needless delay that is occasioned by having to ask every time I show a document. I'm going to show you a document. It's been marked as exhibit whatever for identification. Do you recognize the document? Yes. Can you tell me what the document is? And then we'd like to move for its admission. Because usually those documents have already been produced in discovery, and it can be whittled down to 5, 10, 20 documents, depending on the volume, where there really is a meaningful dispute about its ability to be admitted into evidence, either based on its relevance or, whatever. That didn't happen here, but I don't think it changes the court's standing policies and procedures, which are that we're not going to try a case where nobody knows what the documents are coming into evidence. And so I ultimately, at the CPTO, if at the pretrial conference, if not before, I order the parties to engage in a meet and confer and say, here are my documents, here are my documents. They're pre-marked, and let's figure out what is objected to and what is not. And so I think that alleviates some of the city's complaints about the trial by ambush concerns. The motion that was filed by Mr. Ash was to enforce the agreement, and to the limited extent that I've just outlined, I'm going to grant that motion, right? Which is that I believe that the plaintiff did agree to a cursory list of damages, and I believe the plaintiff did agree to produce some documents in its discretion, and I'm going to require that it do so. But again, because of the limiting language that was used in the agreement, I think the plaintiff has a great deal of discretion in terms of what it produces and what it doesn't. I'll ask that, understanding the trial strategy decisions that are made and that have been made based on, as Mr. Henderson put it, the situation on the ground as it has existed for some time. I'm not asking you to give away the bank, but I am saying that ultimately it's an easy decision for me to enforce that limited scope of an agreement, because I would otherwise require you to produce your documents at some point before trial. So what that means then is, what of the rest of the request, which is to reopen discovery and to continue the trial? I am not inclined to reopen discovery. Whether it is unfortunate, and whether it was by oversight or by design, the city chose not to engage in the discovery process while the case was pending. And as a function of that, we're not going to reopen the matter after it's gone up on appeal and come back and been set for trial. Now, that does not mean, to Mr. Ash's point, that if in fact plaintiff is engaging a new expert, that immediately before trial, they might not be entitled to have some information about what that expert might say. And again, it is limited to the caveat. I caveat that statement with the point I made to Mr. Ash, which is, again, the city, whether by design or inadvertence, declined to pursue significant review or discovery relative to the originally identified expert. And so I'm not, generally speaking, I guess here's the way I'm going to say this. I am going to treat plaintiff's new expert, if that's what it is, as a late identified expert, and give Mr. Ash some limited ability to know who that person is and to inquire to a limited extent what that person's opinion might be, at least to know who it is. And what, if y'all are providing a damages summary, what that expert's opinion will be as to damage, in terms of just a dollar amount. And so then that leaves me, after I'm done, y'all might have some questions about what my specific ruling is and how we're going to handle this going forward. But that leaves me, in my opinion, with the question of continuing the trial. And while I understand that this is a valuable piece of property that has the potential to result in an award in favor of the plaintiff and against the city that is sizable and is, over what, I guess, 7 figures, it does seem to be a relatively closed universe of issues here. I mean, it's a building that was there and then it was knocked down. And really, the issue here is going to be, what was the condition of the building prior to its being knocked down? Because obviously, the city had an opinion about the condition of the building early on because it ordered its demolition. And as I've always understood this case, the plaintiff's entire argument is, but we had, through permits and other construction, invested substantial time, effort, and resources into improving the building, and therefore it had, not only should it not have been subject to demolition, but it had a larger, much greater value than the city might have imagined it to have at the time that it was demolished. And that doesn't seem like that complicated of an issue, despite Mr. Ash's late arrival to the case. And so the answer is going to be, I'm enforcing the agreement for mediation to the limited extent that I mentioned. I think it's paragraph 1 and paragraph 6 of that agreement. I am denying the motion for continuance, and I'm denying the motion to reopen discovery, with the exception of requiring the disclosure of the plaintiff's new expert. And then Mr. Ash, if there is, once you have that information, if there is a specific issue associated with that, we can talk about that. I am going to ask Mr. Henderson to please prepare the court a proposed order denying Mr. Ash's motion, except as to the motion to enforce paragraphs 1 and 6. And I'm going to include in there I don't think I'm adding anything, but I'm going to require that the pretrial conference that's scheduled for the 6th, that the parties have exchanged documents and engaged in a meet and confer by then, so that we can have a meaningful conversation about what we're going to be talking about at trial. And that would at least give the parties 2 weeks to, with knowledge of what the documents are that will be offered, to engage in pretrial discovery that they're entitled to, and to prepare for trial. That's going to be my ruling. So that was a little bit all over the place. I tried to stay in line, but it was a little all over the place. What questions, concerns, requests for clarification do the parties have regarding that ruling? Mr. Ash, it was your motion, so.
No, I think it's clear, Your Honor. I guess as part of the expert, if they do pick a new expert and disclose his report, his or her report, I assume we'll get the documents that are associated with that. That's part of the pretrial disclosure that I think the court just concluded with. So, assuming that's true, then I understand where we are, and we will see you next Thursday as well.
I think you've correctly understood. Keep in mind that I'm not suggesting that Mr. Henderson, on behalf of the plaintiff, is required to produce, for example, if, whoever this expert is, let's say they've been retained for a year and they have a file that is, 2 binders thick. I'm not suggesting that they have to produce the entire file of an expert in the manner in which a traditional expert disclosure might be made. But the identity of that person, a general understanding of, I believe the standard is who the expert is and what is the nature of the opinion they're expected to offer. And here, that necessarily will be what is the expected value of the building that was knocked down.
Sure.
And so, yes, that's my understanding as well. Mr.
Okay.
Henderson, questions, clarifications regarding what the ruling is, sir?
Yes, Your Honor. So I just want to make sure that I don't step outside the box on any of this. The cursory list of damages and the sum documents at our discretion, at what point do those need to be provided? Prior to the pretrial conference?
Monday.
Okay.
Monday, November the 3rd?
That's probably right. Monday, November 3rd. As far as disclosure of the new expert, I'm required to identify who they are and what their opinion is, but not necessarily to provide other documents associated with that opinion.
Well, let me say this. If in the traditional discovery context, there's obviously a much larger universe of information that you're allowed to request and demand as part of discovery regarding an expert and what information they use to form their opinions and what's in their file and everything else. That's not what I'm suggesting. However, what you're going to have to send a consolidated pretrial order to Mr. Ash, and it will necessarily have to include that expert's name, right?
Yes, Your Honor, of course.
And to the extent that you're going to have that expert testify, one presumes there will be some information regarding what documents he relied on or how he reached his opinion. And so what I'm expecting is that the identification of the expert, that the only thing you really have to add to what you would otherwise be obligated to disclose in the consolidated pretrial order is some information separately or otherwise as to the nature of the opinion that expert intends to offer.
Understood, Your Honor. And is that part of the meet and confer and the pretrial sort of process,
Yes.
or is there some other deadline for that? Okay.
It'll be part of the meet and confer.
I don't. And lastly, Your Honor, and so there would not be then a deposition of that expert. I just want to
No, sir, I'm not reopening discovery, and I'm not allowing deposition practice as to, I think the two specific requests I heard were, one, your client, which and your expert. And at this point, I'm definitely not allowing a reopening of discovery as to your client. And I am not inclined to offer or allow a deposition of your new expert, but because I am designated that person a late disclosed expert, if there is some issue, I can envision an issue that might arise in which Mr. Ash would ask me to revisit that issue, and so I'm leaving it open for now.
Understood, Your Honor. And I think the last sort of point I want to make sure I understand is there's also been an evidentiary subpoena issued for a trial deposition of my client.
Okay.
My client will be appearing at trial. He will be made available for testimony at trial. He's submitted himself to the jurisdiction of the court. And my understanding of the use of the trial deposition procedure is that it's appropriate where the court can't compel the person to appear at trial or won't appear at trial. And so that trial deposition is made necessary.
So that issue isn't necessarily before me right now because the note, I don't know, as I sit here right now in the docket, if that notice of trial deposition has even been filed. And certainly no formal objection, not that you have to actually file something, but that issue is not before me. And it is my hope that with some guidance about this, and a clear expectation and understanding of what needs to be accomplished before Thursday, and an expectation that the case will go to trial, if not resolved, in the third week of November before Thanksgiving, that perhaps the parties can work out those issues. And to the extent that they cannot be worked out, then we will discuss it at the pretrial conference.
Excellent, right? And then that's what my follow-up question was going to be, was if we could hear, we'll get the challenges filed, if we could hear those at the pretrial conference. I think that would be.
That's my expectation.
And then also there's the motion to reconsider pending from the city, and we ask that be heard at the time also, as it has some effect on trial strategy as well.
Forgive me, can somebody tell me what docket number that is?
Oh gosh. Yes.
Wait, was it filed on January the 22nd of 25?
Sounds like approximately.
No, yeah, that issue was not. Yeah, the court didn't rule on it because it was obviated by the filing of the notice of appeal. So yes, I will make it a point to go back and revisit that issue and determine and provide the parties with a ruling on that motion for reconsideration.
Thank you, Your Honor. I don't have anything further. I appreciate the court's indulgence. My verbosity.
Anything else from anybody else?
Thank you, Your Honor.
Okay. Mr. Henderson, if you can make sure that I have that proposed order by no later than tomorrow, I'll make sure it's on file for you by no later than tomorrow. Okay.
We'll have it to you today, Your Honor. Thank you so much.
Excellent. Thank you all. Have a